March 1st is a financial guillotine for a lot of green card holders, because if the policy guidance now circulating is implemented the way lenders are already preparing for, a single fact about you could make an entire business ineligible for government-backed capital. You're not a U.S. citizen yet. Not risky, not unqualified, not in default, just not a citizen. And that one status label can block SBA-backed loans that many immigrant entrepreneurs rely on to survive, expand, and hire. Now add the second layer. The same month you lose access to that capital lane, you may also face longer, more invasive re-entry inspections if you travel. Not a travel ban, something worse in day-to-day life. A friction regime, secondary inspection, phone questions, social media questions, missed connections, lost money, a quiet message that your lawful status doesn't guarantee a smooth life anymore. And then the third layer, a public charge enforcement posture that's being signaled as stricter and broader, mainly aimed at applicants, but casting a shadow over permanent residents who are preparing for citizenship. Because in this climate, citizenship interviews are increasingly being used as audits of your entire history. If there's a discrepancy in your past, you can be forced to defend decisions you made years ago. Stay with me, because I'm going to walk you through 5 major changes that green card holders are dealing with right now. Some already active, some rolling out, some set to hit like a deadline. And every 3 or 4 minutes, I'm going to show you the hidden trap inside each change. The devastating mistake that turns a manageable issue into a life-altering problem. By the end, you'll have a clear action plan you can start today. This is Immigration News Desk. And I need to say this up front. I'm not here to spread panic. I'm here to map the terrain. Because the terrain has changed. And when the terrain changes, the people who survive aren't the people who feel the most confident. They're the people who prepare the earliest. Let's talk about why green card holders suddenly feel like the ground is moving. Historically, lawful permanent residence has been marketed as stability. You can live here indefinitely. You can work, you can travel, you can build. And legally, much of that is still true. But operationally, the system is moving toward continuous verification. And continuous verification doesn't always announce itself with a new law. It shows up as new lender requirements, new screening patterns, new internal USCIS postures, and a culture shift that treats every immigration benefit, even citizenship, as an opportunity to recheck the underlying record. Here's the uncomfortable reality. You don't live in the law. You live in implementation. And implementation is where your life gets delayed, blocked, or flagged. Now we start with change number 1, the one with a clear date and an immediate practical impact, SBA-backed lending eligibility. According to the source material you provided and the lender chatter around it, starting March 1, 2026, SBA lending is shifting toward a requirement that 100% of business ownership must be held by U.S. citizens for SBA loan eligibility, not controlling interest, not 51%. 100%, which means if you are a lawful permanent resident and you own 10% of a business, or 5%, or even a tiny stake that you thought was harmless, the whole business becomes ineligible for SBA-backed loans under that structure. If you're thinking, that can't be right, it sounds extreme, that reaction is rational. It is extreme, and that's why it matters. The SBA is not a private bank. SBA-backed loans are a public policy tool that lowers risk for lenders and opens access for small businesses through favorable terms. Longer repayment periods, lower rates relative to many private products, and standardized underwriting. Immigrant entrepreneurs have used SBA programs for decades, not as charity, but as leverage to create jobs and build tax-generating businesses. The devastating mistake here is assuming this is not your problem unless you personally plan to apply for SBA loans next week. That's the wrong lens. SBA rules shape downstream behavior. If SBA-backed capital tightens, private lenders follow with their own risk filters. Investors adjust terms, the market shifts, and immigrant-owned businesses become more expensive to fund even outside the SBA ecosystem. So what do you do if you're a green card holder who owns a business or plans to? First, you treat March 1st like a deadline, not like a rumor. If you are already far enough along to apply for SBA-backed financing and you can file before March 1st, you need to talk to your lender immediately, not sometime. immediately, because once eligibility rules shift, you don't get grandfathered just because you wanted to apply. Second, if you are not ready to apply, you build alternative funding lanes now. Conventional bank loans, lines of credit, SBA-like private products, CDFIs in some areas, equipment financing, receivables financing, private investors, structured partnerships, or even a strategic pause in expansion to avoid predatory terms. This is not motivational talk. This is survival planning. Third, yes, if you are eligible to naturalize, you should seriously consider whether citizenship has become not just an identity choice, but an economic access key. And I know the next thought in your head, but citizenship is scarier now too. You're right, we'll get there. But citizenship still changes your relationship to multiple systems, lending, travel, and certain enforcement vulnerabilities. Now hold this open loop. There is a wrong way to fix SBA eligibility by rearranging ownership on paper. People will be tempted to transfer equity to a citizen friend or spouse just for the loan while still operating like the true owner. That can create legal exposure beyond immigration, fraud, misrepresentation in lending, tax consequences, partnership disputes, and the kind of paper trail that later gets used against you in immigration contexts. We'll return to this because desperation creates self-inflicted wounds, and the system is built to punish them. Change number 2, travel friction and enhanced vetting, especially tied to certain destinations and certain nationalities. This one is psychologically brutal because it doesn't always end in denial. It ends in humiliation, delay, and uncertainty. Let's be clear, lawful permanent residents are generally exempt from proclamation-based entry bans the way visa applicants are not. A green card is a strong re-entry document, but in the environment described in your source, green card holders traveling to or from higher-risk countries, countries tied to broader restrictions or enhanced vetting lists, are increasingly reporting secondary inspections upon return, and in most reports, the person is ultimately admitted, but they lose time, miss connections, and sometimes experience invasive questioning. Secondary inspection is not proof you did anything wrong. It is a tool. It's how CBP confirms identity, checks databases, reviews travel patterns, and probes residency intent when a profile matches a risk trigger. That trigger can be as simple as frequent international travel, long trips abroad, recent travel to a flagged region, name similarities, database mismatches, or random selection. Here is the devastating mistake at the border. Thinking secondary inspection is a conversation you can explain your way through by talking more. In enforcement environments, your words are not comfort. Your words are data. You answer truthfully, yes, but you don't volunteer unnecessary narratives that create contradictions later. Now let's address the elephant everyone whispers about: device searches and social media. At U.S. borders, government search authority is broader than it is in your home or on the street. For green card holders, you have stronger ties and due process protections than a visitor, but that doesn't mean your border experience will feel protected. Officers may ask you to unlock a phone, they may ask about social media, they may ask detailed questions about your trip, your work, your home, your taxes, your family. Refusing can be within your rights, but the practical consequence can be longer detention, device seizure, or being flagged for future scrutiny. This is not fair, but it is real. So what do you do if you're traveling and you want to minimize risk without surrendering your dignity? You prepare like an investigator. You build buffer time into your itinerary. If you normally book a 1-hour connection, stop doing that. Build 3 or 4 hours, because nobody reimburses you when a government inspection makes you miss your flight. That's a hidden tax on your life. You carry a simple residency proof packet in your bag, your lease or mortgage statement, a recent pay stub or employment letter, proof of enrollment if you're a student, evidence your family lives here if that applies, and recent tax transcripts if you can access them. Not a suitcase of papers, just enough to quickly demonstrate that your life is anchored in the United States. And you avoid the second border trap, signing anything you don't understand. In some cases, officers suggest that someone sign documents that amount to giving up status, such as a record of abandonment. If anyone suggests you sign anything relinquishing permanent residence, that is not paperwork to go faster. That is a legal event. You can refuse to sign and request legal counsel. If the government truly believes you abandoned residency, there are processes, including proceedings before an immigration judge. But the point is, don't voluntarily erase your status because you're exhausted in an airport room. Now, change number 3, stricter public charge enforcement expected in your source to roll out around late February or early March 2026. Public charge is one of the most misunderstood weapons in the immigration system because it's presented as common sense and applied as a moving target. Public charge doctrine in modern U.S. immigration is used to assess whether an applicant is likely to become primarily dependent on government benefits. Historically, it has expanded and contracted depending on administration priorities, and that matters because the rule's existence creates a chilling effect. People avoid benefits they are legally entitled to, including children's benefits in mixed-status families, because they fear immigration consequences. For green card holders, public charge is not typically used to retroactively revoke your status merely because you used a lawful benefit. But here's the real risk in 2026. The system is becoming more willing to look back during high-stakes applications like naturalization. Citizenship interviews increasingly function as full-file audits. If you used benefits improperly, or if there are inconsistencies in your reporting, you can face delays and deeper review. The devastating mistake here is letting fear drive illegal behavior, like hiding benefit use, lying on forms, or letting someone else file something in your name without understanding it. If you use something you weren't eligible for, you don't fix that by pretending it didn't happen. You fix it by getting legal advice, documenting eligibility where it existed, and correcting mistakes in a controlled way. If you are applying for a green card right now, adjustment, or consular, public charge can be more directly relevant. This is where you need individualized advice, because benefit rules are complex and category-specific. The safest move is not rumor-based avoidance. It's clarity. What did you use? Who used it? Who was the beneficiary? What were you eligible for? And what does the current rule actually treat as a negative factor? Now we reach change number 4, the one that frightens people the most because it attacks the idea of finality, reconsideration, and potential rescission of existing green cards. Your source describes USCIS posture and policy manuals pointing toward review of past grants, and anecdotal cases where citizenship interviews triggered scrutiny of green card approvals from many years earlier. Let's be careful here. The government does have mechanisms to revisit status in certain circumstances, especially where fraud or willful misrepresentation is alleged. But most lawful permanent residents will never experience rescission proceedings. The fact that it is rare does not mean it is irrelevant, because the consequences are catastrophic for the few who are caught in it. Here is the devastating mistake: assuming that because USCIS approved you once or twice, your underlying record can never be questioned again. That's not how the system works, especially in an enforcement-oriented era. When you apply for citizenship, USCIS pulls your entire A file. Every form you ever filed, every answer you ever gave, every address, every job, every relationship claim. If they believe something was misrepresented, they can deny naturalization and, in extreme cases, trigger proceedings that challenge your permanent residence itself. This is why you're hearing stories of people going to N400 interviews and walking into marriage fraud allegations about relationships from a decade ago. Not because USCIS has suddenly become psychic, because the citizenship application is a doorway into full-file review, and in a stricter climate, officers are incentivized to find inconsistencies rather than overlook them. So what should you do if you're a green card holder thinking about citizenship but nervous about your past? You do not avoid citizenship forever as your only plan. You do an audit first. You gather your old filings. You compare what was said then to what is true now. If there are sensitive issues, prior overstays, prior misstatements, complicated marriage histories, old arrests, even dismissed cases, you consult an attorney before you file. Because filing N400 without understanding your own history is like walking into an interrogation and handing the officer the flashlight. Now, change number 5, priority shifts in green card processing, the macro trend that is altering who gets moved faster and who gets pushed to the back. The pattern described in your source is familiar to anyone who watches immigration policy closely. Preference toward what policymakers call high-value immigration, wealth, advanced skills, fast economic contribution, while family-based categories grind slower. You see this in rhetoric, you see it in program proposals, you see it in resource allocation, and you see it in the lived reality of people waiting for siblings, adult children, and other preference categories. Programs framed as investment pathways get streamlined. Employment-based categories with perceived economic benefit get attention. Family categories face longer waits and more bureaucratic friction. This is not a moral judgment, it's policy orientation. The devastating mistake here is passivity. People in family-based categories often think there's nothing they can do but wait. That's partly true. Quotas are quotas. But there are still legal tools. Keeping cases document-ready, responding instantly to requests, avoiding lapses, and in some circumstances using pressure mechanisms when delay becomes unreasonable. You may have heard of mandamus lawsuits, federal actions asking a court to compel an agency to act when there is unreasonable delay. Mandamus is not magic and not appropriate for every case, but in certain contexts, it can force movement, especially when a case has been stuck beyond normal processing times with no explanation. It is one of the few tools that converts passive waiting into active leverage. But it must be done strategically because you're not suing to win approval. You're suing to force a decision, and sometimes the forced decision is a denial. That's why you don't do it casually. Now I want to bring all 5 changes into one coherent message, because if you treat them as separate news items, you miss the systemic risk. The system is shifting from trust to verification, from service to enforcement, from family unity to economic sorting, from predictable processing to discretionary friction. And the result is a new reality for green card holders. You may still have rights, but you will be asked to prove your story more often, in more places, and with higher stakes. So what do you do right now, today, so you don't get blindsided? If you are a green card holder, business owner, or part owner, review your financing strategy before March 1st. If SBA-backed financing is critical to you, talk to lenders now and explore alternatives immediately. Do not engage in fake ownership transfers or paper games without counsel. That's how people lose both businesses and status. If you travel internationally, especially to high-scrutiny destinations, travel prepared. Build buffers, carry proof of U.S. ties, know your rights at re-entry, and never sign abandonment documents under pressure. If you are applying for a green card in 2026, treat public charge and benefits usage like a legal issue, not a rumor. Get real advice. If you are considering citizenship, audit your history before filing. Citizenship is powerful, but in this era, it's also an audit trigger. You want to walk in ready, not hopeful. If you are stuck in a family-based backlog, stay document-ready, track the visa bulletin, and consider legal escalation only after informed analysis. And above all, build your immigration survival file. Copies of approvals, tax transcripts, proof of residence, employment history, travel logs, old filings. In a verification regime, being able to prove your life quickly is protection. We'll keep tracking these policy shifts as they are implemented and clarified. What's real, what's rumor, what's enforceable, and what's being tested quietly, right here at Immigration News Desk. If you've been feeling that vague anxiety that something is changing and you can't name it, you're not imagining it. The system is changing, but you are not powerless. You can't control the politics. You can control preparation. And in 2026, preparation is the difference between a smooth life and a bureaucratic nightmare.